Hi, this is Kosha Grantad from the Grantad Law Group. I want to welcome you to our immigration show. Today we're continuing our J1 waiver series, and I'm answering a question that I had from one of our top YouTube subscribers about how is Department of State evaluating government funding. So I'm going to go into detail about that. First, smash that like button, and you can also put your comments below. I will try to respond if I can, or if you have some video ideas, put that in there too. And if it looks good, I might do a video about it like I am now. Now, before I dive into the question, I really want you to understand a fundamental concept, because I also had a consultation this morning where a really nice lady hopes for getting an exceptional hardship waiver, even though they didn't have the qualifying relatives of a U.S. citizen spouse, or a U.S. citizen's child, or a lawful permanent resident child, or a lawful permanent resident spouse. So I don't want you to be in the dark about that. That is a clear requirement as set forth in the law. So there's no way around that for an exceptional hardship waiver. I just want to make sure you understand that, so you don't have to schedule a consultation with me to figure that out. So that is something that's very, very clear. If you don't meet those basic eligibility requirements, there's nothing that can be done in terms of an exceptional hardship waiver. But there are other types of waivers that you could look at. There is a persecution waiver. There could be possibly a no objection waiver. There could be an interested government agency waiver, especially if you're a physician, such as a VA waiver or a Conrad 30 waiver. So there are possibly other options. Also, if you're at the very top of your field, there may be the O1 visa that's available to you to postpone the 2-year home residency requirement. All right, well, okay, I got off on a tangent here. So let's dive back into the question here. What's going on with the Department of State in terms of evaluating whether or not government funding is an issue? So let's back up our gears here first, go back to the basics here, so you make sure you understand the exceptional hardship requirements. I already just talked about the basic eligibility requirements. Procedurally, what we do is we file with USCIS and United States Citizenship and Immigration Service, the form I-612. Simultaneously, we're also filing with the Department of State. With USCIS, what we like to do is prepare a very detailed legal brief outlining the legal arguments and the factual arguments of why you qualify for exceptional hardship. So USCIS is only the first step in this process, because what they'll do is they'll review the case. Now, if they deny the case, it doesn't go on to the next step. But if they make a prima facie determination that the case could be approved, then they'll send the summary of details to the Waiver Review Division. So they'll send it to, we call that, immigration attorneys just for short call that WRD. So they'll send it to the WRD, and then they will review the application. Now, just some more jargon for you, so you're educated and aware. Not only do we call it the Waiver Review Division, WRD, but we also attorneys may refer, immigration lawyers may refer to the WDRD as the Department of State. Just some things to be aware of when you're learning about this process, because I want you to be as educated as possible. This is very confusing. It's a very interesting and can be confusing area of law, because it has all of these different nuances, and I want to make sure you're aware of them. All right, let's talk about the next steps. Okay, the Department of State, DOS, will make a recommendation based off of the policy considerations of the case, also in relation to foreign relations, and will evaluate whether or not the hardship overcomes the fact that you received government funding. Now, something else that's interesting is Department of State may go back to your government sponsor, and let's look at who the government sponsors are sometimes. So that could be like a Fulbright scholar, or if you actually receive funding from the Department of State. This is not to be confused with funding that was from your home country's government. This is U.S. government funding by the United States government, not solely your home country's government funding. So Department of State may go back and request your sponsor to give what their views are, and then they'll look and evaluate what the views are from your sponsor. So again, Department of State may deny the case if the foreign policy considerations of the exchange visitor program do not outweigh the hardships that you may have. So you can see if you have government funding, you're having to not only overcome USCIS's evaluation, but the Department of State's evaluation. To make matters worse, I'm sorry that I don't like being the bearer of bad news, but my goal is to educate here. So if the Department of State does find that your case should not be approved, then there's no right to appeal. So in that situation, what do? Well, you can file a de novo application, a new application if you have new factors, new forms of hardship. That's one option. Or you can look at other J1 waiver statutory options. An important thing to note is, however, if your case is denied by USCIS, there is an ability to appeal. So there's the difference between the USCIS and the Department of State. Now, under 212E of the Immigration and Nationality Act, that's where it outlines that there must be a favorable recommendation by the Department of State in order for your waiver to get approved. So you might be wondering, well, when do these cases get approved? I invite you to look at our case studies on our website at j1visawaiver.net, and that'll show you some of the cases where we were able to get them approved despite the fact that the applicant had U.S. government funding. I hope this video served you, and if you have comments, please post them below, or if you have video ideas, post them below. Smash that like button, and until next time, bye for now.